This week, the Attorney General Godfrey Adame took over the cross-examination of Richard Jakpa, the third accused in this ambulance trial. And one of the major highlights of AG Godfrey Adame's cross-examination was a letter that communicated the dismissal of Richard Jakpa from the Ghana Armed Forces. We have a copy of that letter which has been admitted into evidence by the trial judge in this case. But first of all, take a listen to Richard Jakpa, and I'll show you the letter. Take a look.
And mischief, that is the Attorney General and the government have created, and using their surrogate media houses to be peddling falsehoods, twisting proceedings of the court, and then bringing out evidence that I have no idea about and trying to put it on me. I want to address that. The Attorney General brought a document, a pile of documents to the court about my military career. I left the military about 17 years ago. Now he brought a document purporting that I have committed certain crimes according to the letter. In fact, that letter I was not copied. I have no knowledge of that letter. And that letter are allegations that are unsubstantiated, unfounded, and I was never confronted with it by the military 17 years ago. And that letter is purported to have been written by one Brigadier General Ahiaglo. In fact, I know Brigadier General Ahiaglo. He's dead. He's deceased years ago. And he wrote that letter on behalf of the Chief of Army Staff, who was by then Major General Odote. So Brigadier General Ahiaglo was a staff officer to the Chief of Army Staff. So he wrote on behalf of the Chief of Army Staff. So this unfounded allegation that I was never confronted with, I was never made known of, a secret report document that they wrote to the Chief of Staff of the Ghana Armed Forces, who reports to the Chief of Defense Staff, the CDS. I have no knowledge about it. In fact, today is the first day I saw that letter, dated.
Well, that's Richard Jakpa. There is the third accused in this ambulance trial. A number of things that he points out, that this is the first time or Thursday was the first day he saw the letter in question, which has been admitted into evidence, as a matter of fact, by the trial judge. And then also the content of it, he wasn't aware. But here's a copy of that letter that the Attorney General dwelt on to, in fact, cross-examine Richard Jakpa when he took over the cross-examination on Thursday. Take a look at this. The release from service for unsatisfactory conduct, Lieutenant Richard Jakpa, and you have his number there. This is dated 12 September 2007. These are the points in this letter. 1. The above-named officer was commissioned into the Armored Corps as a regular officer on 21st August 1998. All things being equal, the officer should have made the rank of captain on 21st August 2002 and a major on the 21st of August 2007. He has consistently failed his promotional examination and now lags behind his mates in rank. Also, his service with the colours has been largely unsatisfactory, marked by consistent fraudulent conduct, abrasiveness, and general indiscipline. And that's why you hear Richard Jakpa say, if the fraudulent conduct was consistent, he shouldn't have been in the army for that long, because just one act of fraudulent conduct was enough to have him sacked and not be consistent. But the letter says so. 2. In addition, Richard Jakpa has incessantly been indebted to various people, institutions during the period. An example was his long indebtedness to the Reki Regiment PRI to the tune of $300, which he was unable to pay till authority was sought for the amount to be deducted from his salary. throughout his service life, Richard Jakpa has proved consistently that he belongs to a world incompatible with the decent and gentlemanly composure that the Presidential Commission confers on officers of the Ghana Armed Forces. In fact, it goes on, and the point 4 essentially explains why this letter communicated his dismissal. From the foregoing, the continual retention of Richard Jakpa is not in the best interest of the Ghana Armed Forces and indeed himself. It has accordingly been decided that Lieutenant Richard Jakpa be released from the service forthwith. And he talks about Brigadier General for the Chief of Army Staff then, the late Brigadier Ahiaglo. He signed this and he's deceased. So, yeah. Lawyer Christian Mamhesi, private legal practitioner, joining us in the studio for this conversation. Good morning. Thank you so much for joining us.
Thank you for having me. Good morning to you and your viewers alike.
Let's establish a few things. Did Richard Jakpa need to know about this document, this letter, before the Attorney General pulled it up during the cross-examination? Was it a requirement per se?
Okay, with respect to the Evidence Act, and when we are dealing with witnesses that are supposed to testify, especially in the arena of admissibility of evidence, and also looking, if you come down, aside dealing with admissibility of evidence, and when you draw further down to section 80, 81, 82, 83, 84, which deals with credibility of the witness, the law indicates that there shouldn't be a surprise. Now, in a situation where the prosecution is seeking to introduce such a document, an application will be made to the court, and for the court to determine the admissibility or otherwise of it. Now, when the court comes to a conclusion that this particular piece of evidence would inure to resolving the matters before the court, then the court would admit it. Now, it would be left to the court to put a probative value on it as to, so when we talk about the probative value, we are talking about the weight that the court would ascribe to it in helping it resolve the matters. Now, when we move further down and we are looking at attacking the credibility of a witness, that, like I said, ventures us to those sessions I mentioned. Number one, generally in educating the public with respect to this particular strategy, as I would say, but it is enumerated in the Evidence Act. It deals with, there are situations where during trial,
hold on a bit. Before we get into that strategy, this letter has been admitted by the trial judge into evidence. It has been admitted into evidence. So then what happens to it? After it's been admitted into evidence, then what next?
So once it's admitted into evidence, prosecution is at liberty to cross-examine the witness on it. And in cross-examining the witness, they will be testing a number of things as provided under the Evidence Act. They will be checking for consistency and inconsistencies. They will be checking, or they'll be testing issues on the substance of the testimony of the witness. They will be also checking on the truthfulness or otherwise of the witness. They also look out for the bias or the motive or any interest that exists. And they'll also check about the capacity of the witness to recall and also to accentuate its mind to some of the facts or otherwise that are contained in the letter. So this whole business by the prosecution is basically to test the credibility of the witness. And where they are successful, it would further water down the testimony that the court ought to ascertain as provided by the witness at trial. And we can also not forget that the value of the testimony, that's the probative value that the testimony of the witness would give out, would inure to whatever the court or whatever conclusion the court would come on. So, I mean, the purpose of cross-examination is to put your case across, and the majority of it is to do everything to water down what the other or what the testimony that the witness is putting across.
In fact, one of the major reactions after Thursday's hearing, that's cross-examination by the Attorney General on this particular letter, is that, well, it doesn't relate to the substance of the case. So how does that even come in? And how does that even impact on the case if it's going to make reference to this letter? But this is just a strategy to discredit the witness. And that's not wrong, you say? It's not wrong in law?
Yeah, so if you look at section 82, it deals with, of the evidence, that it deals with extrinsic evidence. You see, and extrinsic evidence, as we find this, so far as it would discredit, and section 82, all that sections that is contained therein or thereof, it basically is provided there are rules of court with respect to trial that deals with discrediting the witness, and that is rightly what the learned Attorney General is doing. And this is an extrinsic evidence which is seeking to support or to discredit the witness. So it supports its case that is putting across, or to discredit, and also to discredit what the witness is saying. So like I mentioned, under the Act, the various areas of testing the credibility of the witness, whether the witness is consistent, whether the witness has the capacity to recall facts of whether it's non-existent or existent to its case, whether the truthfulness or otherwise of what the testimony of the witness is or has been put across properly. All of this comes to play at trial, and it is enveloped in the extrinsic evidence that the learned Attorney General has put out, so to test the credibility of the witness. At the end of the day, the learned Attorney General believes that this extrinsic evidence would inure in putting its case out. At the end of the day, the prosecution, by the time the prosecution closes their case strategy will be put out there. So you sometimes hear commentary where people say this is a sidebar, it is not necessary. But at trial, there can be a collateral damage. And we say evidence cross-examination is at large. But even though cross-examination is at large, I mean, for viewers, when we say cross-examination is at large, you cannot limit a lawyer cross-examining somebody at trial. But definitely, the court would guide you. When you ask irrelevant questions, it's either the defense counsel or the defense counsel will raise an objection on relevancy and other matters, and for the court to rule on. So yes, cross-examination is at large, but the main thing is that the prosecution or lawyers do during trial in cross-examination is to put your case across and try as much as possible to discredit the witness in there so that you can have a field day.
Professor Jampo, do you have some clarity to that question that you asked me off air? Why does this relate to the case?
But the point is this: you see, I have a lot of people who have been telling me to go back to the classroom to study law.
Yeah.
But these guys are the same people who tell me that law is about 70% common sense.
Yes.
And then 30% the law itself. And I keep saying that I have common sense. So if I have the 70% common sense, how come Martin Bebo and Virginia? How come? But the point is this. I've been wondering, if I tell you that this my flask is black.
Yes.
Okay.
Yes.
And then you, host, you know it is black. My two colleagues here, you all know it is black.
Yes.
And then it is established that, well, I am not a credible person. Will my lack of credibility prevent the description, the known description of this flask as being black? The point I'm trying to say is that, but make is that, I saw the line of questioning, and you guys, I respect your processes. But I asked that, are these questions that they are asking, how are they nullifying the voice that we heard telling the man to say that he is sick, go to the court and say he is sick, and that he should take excuse to absent himself? How does it nullify it? Yes, so you can establish that the guy was not working well when he was a soldier 17 years ago. But how does that invalidate the voice that we heard on the tape? I've been thinking about it, and I'm saying, but is this not common sense? The common sense that you are talking about? Commonsensically, I think that these things do not do much to what has been, unless you see, I was hoping that he was going to just deny that, look, it's not my voice, and adduce evidence to show that it's been doctored and all that. But if you go beyond that and to say, talk about the guy's soldier activity 17 years ago. Look, if you want to look at what people did 17 years ago, Godfrey Dami, if you want to look at what you did when you were a child, then I'm telling you that you may not even be qualified to occupy the position as attorney. If you don't want to go to our past and what we have done when we were children and what we did, I mean, growing up and all that, it may not qualify us for any position, you know. And so my point is that let it be said that some of these things, for me, they contribute to the needless waste of time in the legal adjudicative, processes. When the thing
But it is not wrong. When it is not legally wrong.
Well, it may not be legally wrong, but the point is that we should be seen to also be correcting or be doing things that would address the challenge of delays in justice delivery. Okay, we shouldn't say that whether the processes, when the questions that are being asked do not invalidate what is there black and white, you say cross-examination is at large, so we should just allow it. Another. For me, it doesn't make sense to me. And if you say law is more about common sense, then you see, I was thinking, I said,
what happens is that you see, law is not social science. Law is not social science. Law is based on rules. It's a rules-based order, and this distinguishes law from social science. And you are in a slippery place.
I want to. Let me say law is not social science.
So let me finish my submission. No, respectfully. So the distinction is clear. Now, the point about having knowledge or knowing that, or one is claiming that this flask is black. In the witness box where cross-examination is ongoing, the lawyer cross-examining can cross-examine, extract evidence from the witness in the box, test personal knowledge, whether indeed you saw it. It could be that the person has a perceptive value that the flags is black, but cross-examination will bring out that he does not have a personal knowledge that the flags is indeed black. It does not mean that the flags might not necessarily be black, but the person putting out to say the flags was black, having gone through the processes of law, the court can safely say that this witness testifying that the flags is black cannot be concluded as that.
Right.
Even though that the court knows that the flash is black.
So in that it is a rule based order. Now, the learned Attorney General, in putting this particular thing, I've already mentioned to you that it is extrinsic evidence, which is allowed under the Evidence Act.
Okay.
Now, the theory of the Attorney General in coming out with whatever is doing could inure to its strategy. The issue about waste of time. Now, in courts, we don't necessarily deal with waste of time, even though our rules say that we should avoid needless presentations of cumulative evidence under the Evidence Act. You understand? And so if you are seeking to make an application for an exhibit to be adopted as an evidence, the court considers all of this under Section 52 of the Evidence Act to see whether or not this evidence that you are seeking to put in is indeed relevant, which would not cause undue delay, will not prejudice, will not confuse matters and all of that. Having crossed that threshold, we are not in the realm of whether this is causing delay, because at the end of the day, we have not really come to a conclusion why the learned Attorney General is indeed putting out this, because it's trial. And again, if you look at the sessions that I'm in, 80, 81, 82, 83, it deals and lists the reasons for attacking the credibility of a witness. And indeed, character or trait of character, motive. You said there are recordings and all of that that describe something.
Right.
There could be reason for it. There could be biases for it. The Attorney General is just testing the credibility of the witness, and that is perfectly allowed. As to whether it will inure to his case or not, it is one for the court to decide. That is how come in running commentary we don't cross that red line of trying to preempt the court. We can only educate the viewers of what is happening in court, but that red line cannot be crossed by any commentator.
Right.
You get it?
Right. Thank
Well,
you.
I have reservations about what you just said. You are just speaking the norm, the law, and I mean, sometimes you should also dare to question and to challenge the status quo,
Which is?
so that we would not always be wallowing in that phrase or expression that, well, the axis of whatever justice grinds slowly, and so we are pandering to that. Matters that can be at a certain point in time an issue go to court. The causes we hear it every day because we want to ensure speedy dispense or discharge of
That's a special case.
And then on certain matters too, we want to tolerate some of these things because cross-examination should always be at large. I mean, can lawyers also be daring enough and in sometimes challenging the status quo in a manner that was set up precedent that also will be applied to other laws, other cases? I think
lawyers
I think that you are pandering
the profession of law
in a manner
the profession of law.
The delays in the justice delivery system. This matter, I think, like I said, and like you people have been telling me, this one is common sense.
Okay, well, let me bring Lawyer Martin Pebble, and then I'll come to you, Hasimam, on this. That slippery path that you say, all of this
I didn't
references are on. What exactly is that path? And
No, but you
and
can't
we
say
just want to actually understand respectfully. Just a quick response.
So
before
you
we
don't
move
say
into
law
exactly
is not
what the
social science because you see all over the world when you look, we are recalibrating. You go to the US now, they are tilting towards moving law truly into social science. You go to the UK, you find faculties that law is in the social sciences, it's under social sciences. Okay, so there's a change. I mean, I'm reading in that area, so that's something I'm a bit comfortable with. So it's not safe to come and say that law is not social science. It's a whole thing altogether. You enter comparative law, there are disputes, you read Professor Jeffrey, Samuel's articles, etc. As I told you, I'm doing research near that area, so I'm a bit comfortable there. So just stay off it and make the point. Then it won't get muddled in the debate as to whether law is social science or it's not.
Yeah, but but then again, moving forward now.
So I would say that there's this publication by Cambridge. Right. You see, the argument as to whether law is a social science or humanities has raged since time immemorial.
Okay.
So I understand where he's coming from, but my point is also not dismissive.
Okay.
Yes, my point is also not dismissive because I'll just leave it as that. Because it is an area in academia that a school of thought holds that law is not social science. Okay. Some others also postulate that law could be considered as a social science. Okay. And so there has not been a holistic conclusion on that. So in as much as you cannot differentiate,
I appreciate
for me, it's so basic.
So you just leave it out.
And it's what it's so basic. But the point is about the common sense. I want your take. I want your take. This thing is black. We all know it's black.
It's fine.
And you are saying I'm examining. Thank
you very much. You made your point. Now,
what are you talking about?
People, so what the Attorney General did in law is it is lawful. The cross-examination and the reference to this letter I just made is not out of place.
Yes.
It is not.
It's not, except that it doesn't go far at all.
Why?
You see, counsel already told you. And even Japa gave the answer. Let's just go straight to the answer. This letter that seeks to disparage Japa was not copied to Japa. This is something that his superior is written. Look at the addressee. Can you show? It's so simply, it was not to Japa. Your boss is writing to GHQ. Okay? So his boss, Ayaglo, is writing to GHQ that this is what I think about the individual. And you see it, look, ask yourself, in that letter, as you read, consistent fraud, this misbehavior, do you see him say that any disciplinary committee found Japa liable, any court martial? No. So this is not the letter that took Japa out of the military. The one that took him out, do you see that the prosecution, they've not let it out, but they leaked this one to social media so that it will be used to, confuse people. Please disregard this letter. Japa is
this
told
letter should be disregarded.
just disregarded. This is not. Do you see Japa's name?
Material enough?
At all. There were three letters.
There.
Yeah, so let's go over. There were three letters that were tendered. Have you seen the other two? The other two that have not been brought out are one. Dami wrote to this guy, Minister for Defense, Nituwu. And Nituwu responded that, okay, this is what I have on him. So Nituwu's own is a cover letter. Then you find this letter which they've let out into the media. But the one that released Japa simply says that they are releasing him and then they'll pay his entitlement. So as far as Japa is concerned, and that's the record, he was not dismissed. So this letter is useless. I mean, let's use.
But you see that this has been admitted into evidence.
Yes.
You describe this as
okay, good. I'm talking here on this social and political platform. That's what I mean. Now, if you are going to court, the thing that what Japa is standing trial for, right, is about causing financial loss, blah, 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 blah. This letter, as I've said, Japa was not copied.
Okay.
Japa has never had the opportunity to dispute this. So you are not now coming to ask him to dispute this in court. Look at the date, 2007. Ahiaglo is dead. The author of the letter is dead. He is dead.
Does that invalidate the details of it?
So I'm telling you that this letter.
No. Yes.
It's not there.
No, it doesn't invalidate. So as for being, you see, under the law, the judge admitted it as official records. We are calling section 120 of the Evidence Act. That is an official record. So the judge will allow it. But I'm sure counsel mentioned it. The fact that a court has accepted